Yeah.
Awesome.
So I was anxious to see it this morning because I was thinking about Wilson going, I wonder if I could find the podcast and share it to him on LinkedIn just to say, hey, you may like this subject matter if you're interested in real estate.
Yeah, he would love that. He's landed a little part-time job where
What's it doing?
he's learning how to flip houses.
Really?
I know. I'm like, oh my gosh.
Is he working with an investor or something?
I think it's like a team that has an investor side and another side.
Sorry to talk like
and he goes out with them and looks at properties that are just anything that can flip over. And so he's helping them scope out properties and going with them and like photographing them and all that. And yeah,
I can't think of anything better.
I know. He loves that, and I'm like, and it's in Columbia, so their real estate is pretty affordable.
Well,
You've got lots of options.
This lady lived in California, and she said her portfolio is primarily houses that she's located. In fact, one of her markets is Augusta, Georgia, and she looks for things under $100,000. And she's not necessarily a flipper, but she's a value add. So, but these guys, what they were talking about, it's a bigger pocket real estate. It's pretty cool. I kind of wish I could get my way back to change. And sorry. Okay.
I just roll into. Right. So it's already shared, but if you want to see the other document, just hit share.
Okay. So
Perfect. Thank you.
It's like, damn, I don't want to know.
Is that better?
That's much better. Thank you.
Can you guys online, can you see the BBA perfectly? Anybody?
Yes, I can. Yes.
Yeah.
I'm going to try to sit where I'm on camera. No, this seat is actually, I think. Right here, back here. Right there. I don't know if they can see. Okay. I need to be close enough where I can see. Thank you guys for coming out. This is BBA, when and how to use it. I wanted to go over what it says so everybody's on the same page when using the BBA, that they're explaining the right things. How do I get rid of this?
For me, because I never even thought about business.
Apologies.
There we go. And if you guys have any questions online, I'll be checking the chat, so just let me know that as well. Thank you, Scott. Okay, so with your BBA, you're meeting a buyer for the first time. You haven't gone through your consultation. Last week, 2 weeks ago, we did buyer's consultation. So you've explained the process to the buyer. They're ready to move forward working with you, and now you want to go through the BBA agreement. The very first line on the contract, state law prohibits broker from representing buyer as a client without first entering into a written agreement with buyer under that section of the law. So what that means is we are not allowed to work with any buyers until we have this signed. Any buyer that has a problem with signing it, first and foremost, we just say that it's state law that we have to have some type of agreement. the brokerage will also require you to have some type of agreement in place. And the reason why, as we go through the contract, is to protect your time, first and foremost, to make sure that the people that you're working with are exclusively working with you. And then also to protect your money once we're under contract so that you get paid for the work that you've done. Section 1, I'm going to read some of it, but I'm not going to read all of it because you guys can go back for reference, but I want to at least touch on several important things within the contract. So exclusive buyer brokerage agreement, engagement agreement for and in consideration of the mutual promises contained herein and other good and valuable consideration, the undersigned buyers, and the undersigned broker do hereby enter into this exclusive buyer brokerage engagement agreement on the terms and conditions set for herein. We represent the broker. So in every situation, it's a relationship, not necessarily with you specifically. The buyers enter into an agreement with Keller Williams Atlanta North. We're using all of our GAR docs, and we'll go over that shortly, but the brokerage relationship is not between you and buyer, it's between buyer and the brokerage. The term is the beginning date, so if you're meeting with someone today and you're starting their agreement, today's date will be start date, and then the term can be dependent upon when they're ready. If they're actively ready to look for a house now, then we can be okay with a 3-month time frame. If they're looking to be in a house before the end of the year, I would more go 5 months, 6 months, just to make sure that I have enough time to do what it is that they need to do. If they're way out and they're looking in the spring, I would do a 1-year contract. Again, just to protect my interests. I've never had one that far out. I typically work with people who are between now and the next 6 months. And then we just nurture the relationship otherwise. But your terms are going to be important, and we'll get into why later on. The agency agreements that are offered are not offered here. We do seller agency, that's working specifically with sellers. We do buyer agency, working with buyers. Designated agency means that 2 people within KW have represent the buyer and the seller. So if I have a listing and Lynn has a buyer, we are designated agents because we're both Keller Williams Atlanta North. You're working with your buyer, I'm working with my seller, but both are signed to a contract with the same brokerage. Does that make sense? Whereas a dual agency is my listing, my buyer. I do an open house at my listing, a buyer comes in, they want to write an offer, and I'm representing both parties. Dual agency is allowed. It's very tricky to do. Have you ever done dual agency?
I'm scared.
Okay.
Yeah, I'm nervous.
You have to get that approved by Jen, right?
So in reading the BBA, the buyer automatically agrees to dual agency.
Okay.
What I've been told is you want to get it in writing by both buyer and seller, acknowledging just one more time that they realize that I'm representing both parties. In writing, that they're saying that I agree for you to represent me as the buyer and you to represent me as the seller, both as clients in this transaction. You have, if a buyer came into an open house and they just want you to write the offer, but they know what they want to write, they don't want any advice, you can treat them as a client, as a customer, not a client. And that would not be dual agency. But again, you want to specify exactly what your role is and make sure everyone is aware. Because if you're working with a buyer, you've already talked to them about their finances, what they're looking for, what they're willing to do and not willing to do. So you know some personal information about them that can sway your decision-making when representing the seller. Likewise, you know the seller, you know what their bottom line needs to be, you know what their timeline is, you know more intimate information about the seller than another agent would. So you have to make sure that you're wearing both hats, disclosing what needs to be disclosed and not overindulging in information that can sway a decision. So dual agency is allowed, however, it's not truly recommended because you have to maintain pure professionalism and only disclose what's necessary to disclose. And sometimes what's necessary becomes blurred.
What, I'm sorry, that's an understatement.
Yeah,
It's
yeah.
blurred.
And it can start out great, and then inspection comes, and then all of a sudden things hit haywire, or appraisal comes and things go haywire. And now you're in the midst of two emotional clients fighting over one contract, and you are the go-to person. There's no buyer's agent to bounce things off of, it's you. They're both coming to you with their joys, their hopes, their dreams, their frustrations, and you have to deal with all of them.
Their anchors.
And a lot of anger, a lot of emotions. I've only done it once. That was my second year in the business, and I've only done it once. So in that situation, if you do have a dual agency, what you can do is you can refer it to another agent in the office and change it from dual to designated. And so when I was new in the business, I used to, in my listing appointments, tell sellers, you know, if I brought the buyer, I would reduce my commission from 6% to 5%. And they were super excited about that because for them, it was paying less money. And for me, it was me getting both sides without having to have that negotiation conversation up front. And then I realized, I don't know that I really want to get both sides. And if I do, I have another agent that I can refer that buyer to. They can work the deal, I get a referral fee, everybody's happy, and we move forward. So be very careful when you're deciding to do dual agency, just because a lot comes with it. Landlord agency, as we represent landlords, we represent tenants. Sub-agency is the only box that I check that is not offered. And my understanding of sub-agency is the old form of real estate, kind of like with new construction, where the buyers go directly to the seller's agent to handle the deal. Buyers have the right to have their own representation, so we don't necessarily do sub-agency anymore. Here, again, in section 3B, if you check off buyer does acknowledge dual agency, then it's their way of agreeing to it. If they say, no, I want you to change it, then you change it. But by selecting this and then signing it at the end is their way of acknowledging. I would still go a step further if they saw one of my listings and remind them that I represent the seller, have the seller know that I represent the buyer, and everybody is on the same page.
And you say remind them like in writing?
Absolutely in writing. Absolutely in writing. If it's not written, it doesn't exist. Number 4, with regards to commission, basically it's saying that the buyer's going to pay the commission, and whatever commission you put in there, that's what they're agreeing to pay. Now, in 99% of our real estate transactions, the seller pays the commission, and so this is never an issue for the buyer. During the height of the pandemic, we had a lot of investors, and they were offering 2% or 2.5%. So if my contract says that I'm due 3%, and there's a listing that says it's 2.5%, then I need to have a conversation with that buyer and let them know that they are obligated to pay my 0.5% commission. Some agents enforce this, some don't. But typically what you do for one, you have to do for all. So be very careful on whether or not you're going to enforce this. A lot of times this is the section that buyers will have questions on because it's stating that they're going to pay your commission. So you want to be clear that that the seller pays the commission. And if there's a house that the commission is less than the 3%, you would have a conversation with them beforehand. So you don't want them to fall in love with the house and then realize that they have to pay an additional point or a 0.5%. So I let them know beforehand that this has a lower commission. If they're still interested and they agree to pay, then we move forward. That commission piece is added to their final settlement statement at closing with how you're getting paid. So it has to go through the lender. You have to verify that they can afford to do so, whether it's cash or with financing. If you're doing a lease, this 4C has to do with the lease terms, and you will put in your dollar amount and your term here. This for me is usually zeroed out because I don't really do leases anymore. the protected period. Protected period is going to be the time frame that after your agreement expires, that if that buyer has not found a home, it's the time where all of the properties that you show, if they go back to one of those homes and put it under contract, they have to come to you to write the offer. So I typically do 3 months. If there's a house in this market that's still on the market after 3 months, the likelihood that my buyer's gonna want it is slim, but still, just to protect myself, I do 90 days. And I've had a situation where for a listing side, the listing agreement expired, and the day after the expiration, we got an offer. Literally the day after it expired. No offers, very few showings. The day after we expired, we got an offer. But because it was still in my protected period, I was the one to facilitate that contract and get it to close and got the commission check at closing. So this is a time period, again, once that contract expires for buyers, sellers, whoever, the time after the expiration, if that buyer were to receive an offer or seller receive an offer or the buyer want to make an offer on the properties that you've shown, they have to use you. That piece is important because we need to keep record of the properties that we show buyers. Because you need to prove, if they were to use another agent, that you're the procuring cause, you're the reason why they went into that house, they fell in love with it and want to write an offer in order to justify your commission. With new construction, sidebar, if your clients are going to new construction, always have them register. You want them to go with you, ideally. Sometimes they go out and do open houses and look at new construction on their own. But when they register, make sure that they're using your name, that they are acknowledging to that sales agent that they have a realtor and that you are the realtor. Regarding protected period, in my second year, I showed a new construction property, but I didn't register the buyer. Our protected period, our contract ended, and they went under contract with this new constructed during the protected period. But I had no proof that I'm the one that showed them this property, and I'm the one that introduced this to them to the neighborhood. My name was not in their system when they were registered. I didn't get the commission. So protected period protects you when they write an offer for the next property, but it only protects you if you have proof that you were the reason that they saw this house. Does that make sense? Any questions about that?
I heard it's good to send an email at the end of the buyers, when the BDA expires, send them an email, making them out of record. But these are the properties that we've reviewed, and they will be considered within the protected period.
In my showing tours now, I use showing time and do showing tours to document all of the houses that I've shown. Some people would keep their MLS sheets. That can be a lot of paper, but any way that you feel fit to acknowledge, even if it's the text chain, the email chain, the paper trail, whatever type of system that you're gonna use to acknowledge, we're seeing these properties, or I've shown you these properties, just hold on to it until after closing.
Would like a super key log be sufficient? Like if you use your super key to enter like a resale property?
It can be,
Because there's no proof that that buyer was with you.
you would have to be very specific, and when you're filling out the showing time, that it was for this particular buyer. And then if there's a property that you, say you were out of town and you hired me to go show your property, you're still the procuring agent, but I'm the one that hit the lockbox and walked them over the door. So yes, it can help, but I wouldn't have that as a surefire proof, just because there's so many things that could happen that you just want to be ironclad. So that could be one of them, but just not the only one. So when I'm talking to a buyer, I let them know this is the nitty gritty, and then pages 2 through 6 are going to be legalese explaining everything on page 1. So number 1 exclusive buyer brokerage engagement agreement. This states that the buyer is agreeing that they are not working with another agent, that if they have worked with another agent, they've terminated that contract, and that they are in agreement with working exclusively with you until closing. This is your protection for the time that you work with this buyer, but understand you still have to ask the question, are you working with another agent? Have you signed an agreement with another agent? You just wanna make sure that it's a clean transfer or clean contract, and that there's not another agent that's gonna pop up and say, wait a minute, that's my buyer, and that's the property that I showed them, and cut you out of the deal. The terms of the contract. The beginning date, the end date are important, because if you have a buyer that's under contract and that contract falls through, let's say we're under contract for 3 weeks, it doesn't appraise, seller says they're not gonna reduce, we end up terminating. 3 weeks can be added on to that end date to extend your buyer brokerage agreement, because you've lost 3 weeks being under contract. And that will be important. And I'll give you another personal mishap. That will be important if your buyer brokerage agreement ends and the buyer is still looking. You'll always want to know when your end date is, because sometimes buyers don't find a home in the first 3 months. Sometimes they take a break. Sometimes the market is just so hard they can't do it. They can't compete. And so you want to keep an eye on when that expiration date is. And I believe it's 5 days before expiration. You talk to them about extending. If they've been under contract, like I say, for 3 weeks, then you would extend the BBA for 3 weeks. You don't lose that time just because you are under contract. But you want to have a conversation with your client about it. I had a client, we were under contract, the deal fell through. It fell through and our agreement terminated within the time period that we were under contract. Now, if your agreement terminates while you're under contract, again, it's extended until the end of, until closing. You don't have to renew for another 10 days because closing date is 10 days away. But because ours was terminated, because our contract was finished and the agreement terminated, the buyer went and found another house and wrote an offer directly with the listing agent. Not understanding that the time that we were under contract was added on, so that end date was not the true end date. If it said September 1st, it was actually September 22nd because we were under contract for 21 days. That buyer ended up paying my commission because they cut me out of the deal. So you want to make sure that you're aware of the terms, and that as we get close to the end of the contract period, you're having a conversation with that buyer saying, you are not penalized because we were under contract for this time. This amount of time that we were under contract actually extends our VBA so that we can continue looking and find your home. Now, for the purpose of extending, if you're close to finding something, then that 3 weeks is fine. If they're in agreement with extending, I would probably push it out a little more for the sake of giving yourself ample time to find a home and get under contract, which is typically a 30-day time. So you're extended 3 weeks if you're under contract for 3 weeks. But if you're still looking, you may want to redo the contract with new dates and new terms to give yourself enough time so that you're not having to renew every 60 days or every 3 months, depending on the buyer. Any questions about extensions? When and how to use them? Let me just check here real quick. George asked if for commission, is it always 3%, and is there any situation where that it's less than? The commission is, for the BBA, the commission is whatever you want. I use 3% as an example. So if you wanted the commission to be 4% or 1.5%, that is totally up to you because this is your business. Typical in the MLS is 3%, and so anything less than, we let the buyers know so they can be aware if they're gonna have to pay a difference. But if you're okay with 2.5, then that's fine. You don't have to make any changes. we
And,
tend,
and,
I'm sorry?
and yeah, the reason I'm asking that question is because this is typically this is a change. It used to be the seller paid the commission, and so this is somewhat new. So I'm just trying to gauge how you present that to your buyer. And say, for example, you say, okay, we'll say 1%, because you're thinking that the seller is going to pay 2%. That would bring you up to the 3%. So do you gauge it like that, or do you just say 3%? Hope the seller is paying 3% and it zeroes out, and everybody's happy. I'm not looking to say we're going to get more commission out of you. I'm looking to get back to where it was normally before. So if that makes sense.
Yes. So commission is one of those things that actually is in fight with, we're hoping that NAR is backing us up. Sellers are trying to get out of paid commission. Right now in Georgia, our agreements are that the seller will pay commission, and whatever that commission is negotiated with the listing agent and the seller. And then whatever is posted is what the listing agent is acknowledging the seller is willing to pay as a commission. Typically in Georgia, and I have to say typically, whenever you're online, if you're on Facebook or any social media platform, you're talking about commission, it's highly encouraged that you don't, because it is not a regulation, it is not a rule that commission is 6%. It's just something that we've always done. And so we don't hard fact say that it's only 6%. I've charged 7%, I've charged 5%. And so we don't want to say hard and fast, this is the rule, this is what everybody is doing. But if we're going by what has been done, it's 6%, 3% on the buy side, 3% on the sell side. And so I'm explaining that to the buyer. Typically the commission that's paid is 3%. However, some agents, some sellers will offer less. And so this is just acknowledging that I am expecting 3%, and I'm expecting the seller to pay for it and could put in its entirety. However, if there is an incidence where there's a listing, let's say an Open Door or a Mark Spain listing, that's 2.25, that I'm asking you to cover that difference because you're choosing this property that's paying a lesser commission than another property. Does that kind of make sense?
Yeah, you explained that very well. One last question: if that situation does occur, is there a form that we have to fill out to show that the buyer is paying the additional 0.75%, or is that just a step, or what is that?
It's not a form, but you do have to let the lender know, because if it's going to be added into their purchase price finance, that is approved. And then also we're letting the I take that back. There is a form. The instructions to close an attorney. There's a section on there that acknowledges who's paying what. And so typically it's the seller pays 3% buy side, sell side, but there is a section where the buyer can pay commission and you specify what that is. And then you would have the listing agent, buyer's agent sign it, send it over to the attorney so they can put it on a settlement statement.
Okay, thank you.
But you definitely want to run it by the lender first so that they can make sure the numbers are still good. But yes, it would go into that instruction to close an attorney form. Agency, we kind of talked about dual agency before. Essentially just being very precautious, because you do have to disclose information. If you know of defects in the house, you have to disclose that to the buyer, but without breaching the seller's confidentiality. If that makes sense. So in here, it just talks about what dual agency requires of you and what it does not require of you, and just making sure that you tote the line correctly. We talked about designated agency. You also have to disclose if you have any material relationship to the buyer. So if I'm representing my sister in a transaction, I need to acknowledge that there's a relationship between me and the buyer. Likewise, if I'm selling my mother's home, I have to acknowledge that there's a relationship. If you're selling your own property, you have to acknowledge that you're a realtor and that you're a realtor in Georgia, representing yourself in this property. So we have to disclose all material relationships. Commission comes into play. We talked a little bit about this. We're assuming the seller is going to pay the commission. However, in some instances, the seller doesn't pay the full 3%, and so we're asking the buyer to cover the difference. And a few listings that I've seen, there are sellers that are offering 0 commission, and the buyer is responsible for 100% of that commission, as would be in the case of maybe a for sale by owner. So in your consultations, when you're going over this with your buyers, make sure that you let them know that you absolutely will assist them and represent them with a for sale by owner. But for them to write down the address and phone number and give you that information so that you can reach out and start the conversation. And the conversation with a FSBO is first and foremost asking if they're paying a buyer commission. And when we find out that they are, we're having them sign an authorization to show unlisted property. That is an agreement within our guard docs. The authorization to show unlisted property means that you are giving me authority to show your house that is not on the market and it's for this particular buyer. You're specifying the buyer's name, you're specifying the address, and then you're specifying what the agreed upon commission is. That is your commission agreement acknowledgement. Instead of the MLS saying 3%, this is your way of acknowledging that you will get paid for showing a house that is not listed. So you can absolutely still get paid from a for sale by owner, but you want to initiate that conversation first and have that agreement signed before you take them in the house. When you're setting the appointment with a FSBO, you call them, you let them know the appointment time and day, and that you'll be sending over an agreement that acknowledges that they will be paying, that they're in agreement with paying the commission. In that event, again, buyer's not responsible, but if there's some for sale by owners that will not pay a commission, and that price, that commission will have to go on top of the sales price and then be specified, just like we talked about before, in the instructions from closing attorney that state the buyer's covering all of it. If you're doing a lease, then the lease agreement, the commissions on that will be different, and then just understanding the buyer's responsibility in making sure that you are compensated. And by you, I mean the broker. The broker gets paid, and then they cut your check from their fees. Again, talking about protected period, just making sure that you know when your contract ends, if you've been under contract, how long you've been under contract, so that if it needs to be extended, you're given the proper notice to do the extension so that you're protected. Broker's duties to buyer. Broker's sole duty to buyer shall be to make all disclosures required by law, to attempt to locate property suitable to the buyer for purchase, comply with applicable laws and performing all duties in the broker relationship, assist to the extent requested by buyer in negotiating the terms of and filling out pre-printed real estate purchase and sales agreement. So essentially, we're disclosing everything that we know. We're showing properties, we're writing offers, we're giving input on how to make an appropriate offer. In exchange, we're asking them to be available to see property, to be timely with their communication, to provide accurate and complete information. Here it's important that they become familiar with the property that they're intending to buy. It is their responsibility in due diligence to do their due diligence to make sure that their commute is good, that the schools that they're in District 4 are appropriate, that there's no active termites by hiring a termite inspector, there's nothing wrong with the property by hiring a home inspector, that they're doing everything to ensure that this house is for them. Also here, we're making sure that they are working exclusively with us. They're not in agreement with, I've talked to a few potential buyers and a few agents who've had something similar. where the buyer just wants to talk to 4 different realtors, and whoever brings them the deal is who they'll work with. Your time is more valuable than that. You want to work with someone who's exclusively working with you, and that when you find them a home, your intention is to get it to closing so that you can get paid. And again, for them not to contact a for sale by owner, to give you the opportunity to reach out to that FSBO and make that initial communication. Limits on authority. This is important for us to understand. Essentially, this is basically saying know your role. We don't give advice on finances. We don't give advice on load, radon. We recommend people for them to talk to give them the advice that they need. So we are the general practitioners, and then we would recommend a cardiologist, a nephrologist, any other specialty that they need in order to check out that house, but we are not experts in any of those fields. So be very, very careful in pointing out things. You point out things to the naked eye, but you don't give expert opinions on anything, with the exception of real estate. So we're not contractors, we're not inspectors, we're not lenders, we're not attorneys. Make sure that if they have questions about those, that you're referring them to the appropriate people, and that you 100% stay free and clear from making any type of advice on that. You don't want to give anybody legal or tax advice, and then it goes wrong, and then they're coming back to you because you gave them the wrong information. So B is all talk about essentially just stay in your lane. C, shall owe no duties to buyer, nor have any authority on behalf of buyer other than what is set forth in this agreement. So again, we're showing properties, we're explaining the market, we're assisting writing offers, and we're getting them to closing. Anything above and beyond that is outside of our realm of expectations. Now, if you want to help them stage and clean the house and do extra things, that's fine, but that's not part of the core responsibility of what they're hiring you to do. Shall not be responsible for ensuring the buyer complies with the duties and deadlines contained in any purchase agreement entered by the buyer, and that the buyer shall be solely responsible for the same. This one is hard, but we can encourage, we can't force. We want everyone to stay within our contingency deadlines. We want them to make a decision within the due diligence, not the day after. We want them to have the appraisal done completely or quickly so that we can get to a value and negotiate if necessary within the contingency lines. Not everybody's that way. Some people are very lackadaisical when it comes to deadlines and boundaries, and they will push, and some will let it pass with no consequence and with no fear of consequences. Our job is to let them know when the deadlines are up, let them know what can happen as a result of missing a deadline, and just do reminders. But we're not in the business of strong-arming anybody to do anything. Just make them aware of what the consequences are, and that we're all adults entering these agreements, and they know the consequences of not taking care of their business. Shall be held harmless by buyer from any and all claims, causes of action, or damages arising out of or relating to inaccurate or incomplete information provided by buyer to broker. If you lie to me, it's hard for me to help you. Earnest money handled by anyone other than our broker. So if the closing attorney is the holder of the earnest money, they are the ones who make the final decision as to who gets the earnest money if there's a breach of contract. And any injury to person or loss of damage. I don't want to be sued because somebody slipped and fell showing property. Things happen in properties, but this is saying I'm not the one that gets sued. F, shall have no authority to bind buyer to any contract agreement or to give notices on behalf of buyer other than to forward it requested by buyer. A notice signed by buyer pertaining to a real estate transaction. Under the standard guard purchase and sales agreement forms, notice received by the broker is deemed to be notice received by the buyer. So anytime that we're representing a buyer, we're passing along contract, addendum, agreements on behalf of that buyer. Anything, again, we've talked about it before, if it's not in writing, it doesn't exist, especially if it gets taken to a court of law. The limit on broker liability, essentially, you can't sue me for more than what my commission is. If I'm making 10,000, you can't sue me for 25, because that's more than what I was contracted to receive in this transaction. Brokers shall have no liability for providing information that later turned out to be incorrect or disclose to the buyer the source of the information. I had a buyer, we were under contract, they terminated their contract, and then they did their inspection, came back poor, no meeting of the minds, they terminated, found another property, and they opted not to have a home inspection. You have a buyer that opts not to have a home inspection, just in an email, something in writing, have it where they acknowledge that it was their choice not to have an inspection. This particular buyer, they bought the house, they had a friend come by who looked at the house and gave it a thumbs up. What we didn't know was that the property was on septic, not public. It was owned by an investor. The listing agent copied the MLS agreement from the previous listing. She didn't do her own due diligence. So she just copied what was there before. The investor never owned the property, so he didn't know whether it was public or septic or not. And it was on septic. Had we had an inspection, we would have found out that it was on septic. But nonetheless, they chose not to do it because they wanted to save $500. Saving $500 on a home inspection cost them $5,000 because the septic hadn't been pumped because nobody knew it was on septic, and it started to leak into the house. Now they're a family of 6, 2 adults, 4 kids. So once they moved into this vacant house and started taking showers and flushing the toilet, things started to backflow into the basement. The last thing that you want is sewage backflowing into your basement and not knowing what's going on. They hired a plumber couldn't find the problem. They had one of those people that my mind is waterproof companies. They had one of those come out. That wasn't the problem, it was a septic. And so a couple $100 later, they realized it was septic, and then a couple $1,000s later, they had the septic pumped and cleaned, and everything was fixed and finished. So I always recommend a home inspection for my clients. If they choose not to, for the CYA purposes, have it in writing where they're acknowledging, and it doesn't have to be anything formal, just have it in writing where they're acknowledging that they're choosing not to do an inspection, so that if and when something goes wrong, they're not holding you liable. And they're not gonna come after you because you didn't disclose and you didn't do anything to let them know that it was septic, not public. So we want to minimize our liability. We want to have everything in writing as a way of covering ourselves. Disclosures, you're only giving away, you're only giving information that is pertinent. You're not disclosing anything personal to a buyer or seller. We're also not giving out false information. If you know something to be false, you cannot pass it along just for the sake of getting through the transaction. Because once it comes out, you're going to be a part of that lawsuit. And there were quite a few of those from the pandemic. Disclosure of potentially fraudulent activity. We are not in the business of mortgage fraud.
Hello.
Hi.
Goodbye.
If you know of any potentials of mortgage fraud, you have to disclose. Again, you don't want to be part of any lawsuits or any anything negative that comes out of a transaction. I think most of you guys were in when I talked last week about a fraudulent listing that I had. Were you guys here? You heard it. I got a listing agreement signed by a guy who had land in Roswell. He happened to be out of town, so we couldn't physically meet, but we talked on the phone, and it just didn't feel right. He was just a little too confident about it. It just didn't feel right. My spidey senses were off, so I started to do a little bit more digging. actually went out to the land and talked to some of the neighbors, only to find out that he truly was fraudulent. This guy sent me his driver's license. The driver's license matched exactly the name of the owner. So if something feels right, even though they give you the information and it looks right, but if you still feel like something is off, dig a little further, obviously not trying to alienate your client, but making sure that things are on the up and up. Because had I taken that listing and sold it, things could have really been bad, because I didn't take it a step further to verify he was who he was. Even though I got his ID, even though I talked to him about the land, it could have been really bad. So we're not participating in any type of fraudulent activities. If it feels off, find out, and at worst, talk about it with Cherry or Jim and have them give you some input. If things go south in a transaction, buyer and seller can't agree, buyer's agent and listing agent are in the middle of a war, we have arbitration as an outlet for settling any type of real estate dispute. Before we get to suing, we want to go through arbitration, mediation before we get to a court. So this is basically acknowledging that we do have arbitration. Depending on what board you're with, that's who you would that's where you would have it seen. There is a difference, and in here we're going to talk about the GAR forms. We use GAR forms. It's not required that a transaction be on a GAR form, excuse me. But in this office, we use the Georgia Association of Realtor forms because it's written by attorneys. They have language in here that protects both buyers and buyer's agent, buyers in the process. Only people who will have access to the GAR forms are realtors. And I just want to make sure that I mention this distinction between a realtor and a real estate agent. A realtor is someone who is assigned to a board, Cobb, Atlanta, Cherokee, whatever it is. They're assigned to a board and they have a code of ethics and that they have to uphold. So typically when you see a contract on a real estate form, the RE forms, they won't look like this. They'll be similar, but they won't have the same language. And that person is doing it because they're not a licensed realtor. They're a real estate agent. They got their license, but they never signed up with the board. So these are all Georgia Association of Realtor forms. And when it comes to arbitration, if you're a part of a board, that's where you go to. If that other party is not part of a board, then we have another route to go. If we do have to go through a litigation, we tried the arbitration, it didn't work, we have to go through litigation. We're asking that attorney fees are covered by the buyer or by the prevailing party. So if our buyer wins, those fees are covered. Again, broker refers to Keller Williams Atlanta North, and we are a representation of the broker as a licensee in this office. Buying property unseen, we had a lot of that during the pandemic. I was doing a lot of Zoom calls and FaceTime tours with buyers who are out of state moving into Georgia. We are a representation of them, but they also have to understand buying a house unseen. There are risks associated with that. And so just making sure everybody's on the same page. You could totally buy a house unseen. Just know that there are risks associated with it. And I'm not responsible for those risks once you actually move into the house. I had a buyer buy a house. They were coming from Wisconsin. We did everything through FaceTime. They, even during inspection, they didn't come down. So I didn't meet them. Actually, I've never met them. She could walk into this office right now and I couldn't tell you who she was because everything was done by Zoom. And they bought the house, and then it was 2 to 3 months after they bought the house before they moved in. And when they moved in, it was a couple months after that. So they had owned the property for about 6 months, and they got a notice from the HOA saying that they had unpaid dues. And she called me because she says, well, we don't have an HOA. And I said, yeah, you signed the community association disclosure. You signed acknowledging that there was an HOA and that this was the monthly payment. I don't know what to tell you, but I mean, you got to pay the dues. So I don't know, had her being there, maybe, I don't know her being there would have been anything different, but when you sign documents, I'm assuming that you're reading the documents and that you're aware of everything and that you're asking questions beforehand. So that when you move in and you get a letter from the HOA, that it's not a surprise. Defining what a buyer and seller is, especially if there's an LLC, you want to have record of who the entities are that are authorized to sign for that buyer. Buyer could be husband and wife, mother, daughter, sister, brother, whatever that is, we're identifying who that buyer is. Fair housing, we're acknowledging that we will find houses for them based on their criteria that does not violate fair housing. So I cannot find you a house near a synagogue. If you tell me that you want to be in this subdivision, I'll find a house. But if you tell me to find houses that are specific to anything that violates fair housing, I can't do it. And we're not steering people to be in a certain area based on what we think they need to, where they need to be. So again, buyers are always typically asked about crime, school, who lives in this neighborhood. We are not authorized to get that information, but we can give them resources for them to find it out themselves. Again, these are GAR forms, Georgia Association of Realtors. Governing law and interpretation, these are Georgia forms, so these forms are specific to Georgia and Eastern Standard Time. If you're working with someone who's in California and the deadline is 5 p.m., it is 5 p.m. Eastern Standard Time, not Pacific unless it's otherwise specified. Hazardous conditions, we kind of talked about this before. If the house is in bad shape, buyers really need to pay. It doesn't matter if it's bad shape or not. Buyers need to pay attention to be careful walking through properties. But some properties that are sold as is or right to respect only, right to inspect only. Those are going to be ones that typically are a little bit more beat up, and you just want to be very careful that where you're stepping, that you're not falling, you're not slipping, because those tend to be a little bit more dangerous houses. And again, I don't want to be near or responsible for anyone hurting themselves on property. We are an independent contractor, so we don't work for them. We're an independent contractor of Keller Williams. Notices between buyer and broker, again, and we want to have all communications in a time-sensitive manner, timeliness of the essence, but also in writing. We want to make sure that we're giving them information quickly and that we, for ourselves, CYA, that we have it documented. Referrals, if you have a referral or you're receiving a referral, the referring partner needs to sign an agreement, but also the referring client needs to sign an agreement as well. There are two documents that need to be signed with a referral. And you're also discussing in that first document, broker to broker, on what the commission is, how many transactions it entails, and who the people or property involved in that referral. Statute of limitation, any claims must be brought forth within 2 years, and everything in this document survives termination. Vendors, we are recommending lenders, inspectors, attorneys, and different contractors to our buyers. It is best that you give them a couple options to choose from so that they can choose their own, but it's understood that if we're recommending a third-party vendor, that they still have to do their due diligence. That if they choose to have their own attorney, we can use their attorney. If they choose to have their own vendor, they can absolutely use them. We're giving them options, but it's up to them to vet and to see who they want to go with. So if I refer a lender and that lender is terrible, one, I know not to use that lender again, but it's up to the buyer to say, yes, I want to go with this person, or no, I want to choose someone else. Again, time.
Oh, I'm sorry. I've seen on a couple of real estate listings that the seller's agent has said they designated the closing attorney preferred. Is that allowed?
So I did that actually on the listing that I got under contract over the weekend. And the reason why is there was a concern about a lien on the title. And so we wanted to get ahead of that. So we started title work up front. And for that reason, I want you to use Thomas & Brown because that's who started the title work.
They got the history on the property.
Right. And I've done title work before where there've been IRS liens, and it's a lengthy process to get that taken off. So if we can get it started before we hit the market and have the attorney already on the case, or a probate issue, then absolutely, I wanna go ahead and use that attorney. If it's just a matter of that's my preferred attorney, then I'm gonna put him out. But I'm having a conversation with the agent up front to find out why, so that I know if it's a probate or a title issue, then yeah, they've already started it. But if it's just because you wanna work with your favorite attorney, I wanna work with my favorite attorney. So is it allowed? Yes, because it depends on the circumstances. Is it mandatory? If we got an offer and it was an amazing offer, but it was a different attorney, we would go with that offer.
Yeah, because
I mean, I won't let that be the reason not to go forward with
the
the
lender's
contract.
gonna go with their attorney.
Yeah.
The lender, and 9 times out of 10, it's a finance, so the lender's gonna say, this is who we use,
And
so.
for residential, the lenders don't necessarily choose. Really the agent chooses. It's just who I know can get the job done. Last year, we had a lot of really bad closing attorneys where they don't communicate, there's been problems and they didn't let us know, and we end up missing a closing because of lack of communication between attorney and lender. So it's something that I just don't wanna work with. And if I see that, then I say, I would prefer that we work with mine, because I know if I go downstairs to Thomas and Brown, Shelley's gonna get me to the gatekeeper. Shelley's the gatekeeper. She's gonna tell me where I need to go. So it's
So that's
just,
a conversation we need to have with the listing agent, because it's like when I'm looking at different things, and I'll say, I'll see in the listing, the listing agent prefers using blah, blah, blah. Because I always put Thomas and Brown on my, all 2 times, in my buyer brokerage or my purchase and sale agreement, but it's like if their thing says they prefer someone else, I need to go a level deeper and ask them why. Okay,
and I would do it only if it's multiple offers.
okay,
If there are multiple offers and that's what's gonna sweeten the pot, make my contract look better because I'm using theirs, then I'll go with it. Not a big deal.
okay,
But if it's been on the market 3 weeks and they don't have any offers, we'll go with mine. I don't have any choice.
okay.
But again, if there's a specific reason why, then I wanna find out. But if it's just you wanna use your guide, then I wanna use my guide too.
Okay, that's a good point, thank you.
It's like Open Door and like the bigger companies, they usually have those.
Now those-
Relationships.
Right, and those, because they're so strict, I've always complied. I don't know that I've,
negotiated before.
I don't know that I've, but when I used them, it was in the height of the pandemic and I was competing with 15 other offers. And so whatever it takes in order to be the winner, that's what we did. I don't think I've closed any Open Door since early 22. Buyer defaults, and it's their fault, they owe you a commission. Now, how you collect it is a different story, but they owe you a commission. And there's a difference between mutually terminating and unilaterally terminating. If you mutually terminate a contract, you are agreeing that you will no longer abide, that you guys have separate ways, and that they go their way, you go your way. And so you're not entitled to a commission when you essentially say, I don't want to work with you anymore. So making sure you understand who defaults and which document to use to get a signature on a termination. Is it mutual or is it unilateral? The cyber fraud, this we also have the anti-fraud prevention and cyber theft. You know what I'm talking about. It's a mouthful of a title. We have it here, but we also have the other addendum that needs to be signed acknowledging the increase in cyber fraud, because buyers are getting emails from attorneys, they're not necessarily reading that Thomas is THOMAS, then they get one from TH0MAS, and they go ahead and send all of their money to that link, and then they're out of their money. We had a couple years ago, it wasn't with KW, it was another brokerage where it was Christmas time. Couple was moving from, I think, Connecticut, and they wired their money over the weekend. Wife was on hold with the attorney to verify the information, but she got impatient and she hung up and sent the money anyway. Got to the close of the table and the attorney says, we're still waiting for your wire. And she says, no, I sent it. You sent it, but you didn't send it to the attorney. So not only did they sell their house up north, pack up their family to come to Georgia, sent all of their money to their wrong account. They can't buy the house and they don't have a house, and Christmas is a week away, and they have children that they have to now put into a hotel until they figure out what next. So I always with buyers and sellers, highlight this and make sure that they understand that when they get that wire instruction, to verify the information with the closing attorney. Now attorneys are getting better, they're encrypting the information, but you still want to take the extra step. If you're wiring $200,000, you want to make sure the attorney is getting that money. So I make sure that I point that out, explain it to them, say it as many times, as loud and often as I can, so they understand the risk of being impatient and hanging up the phone. Brochures, these are the documents, depending on what they're looking for, that we're also giving the buyer for them to read through. I put it in, I use .loop. If you're in DocuSign, you can use that. I put it in there and I have them initial at the bottom of it to acknowledge that they've seen it and read it. Whether that's true, don't know, but at least they acknowledge that they did. On this page, we want to have all of the buyer's information. We want to have their name, address, phone number, email address. Historically, we've only got an email address or a phone number, but in the event that we need to send them a letter for notice, for a lawsuit, for commission, for anything, we need to have their full information. So as much information as you can get on here, have them completed. And then this is our brokerage information. Once everything's been signed, then you accept it. Any questions thus far? We hit it right on the head. The only other thing that I had a part of this, I created I stole it. Buyer protocol sheet, and essentially walks you through the process. So you do your consultation, you do your intake, you have them with the lender, you have the proof of funds, you got the doc set. So if you want a copy of this, just let me know. Again, it takes you all the way through closing and even after closing what you can do. So I'm more than happy to share that with you guys. And if you have any questions, you guys know where to reach me. I appreciate you from joining online, and you have a great rest of your day.
Thank you.
Thank you.